As you are entering the seminar, I will start with a brief disclaimer. CLE presentations are intended for educational purposes only and do not replace professional judgment. Statements of fact and opinions expressed are those of the presenters individually, and unless expressly stated to the contrary, are not the opinion of the Florida Bar or its committees. The Florida Bar does not endorse or approve and assumes no responsibility for the content, accuracy, or completeness of the information presented. Any feedback should be provided to the event organizer. Good afternoon. Welcome to the Florida Registered Paralegal Enrichment Committee's November 21st, 2025 free CLE webinar, What the 2025 Civil Rule Changes Mean for Paralegals in 2026. During the webinar, if you have a question for the presenter, please post it in the question and answer section at the bottom of the screen. The chat feature has been disabled. Some of the questions will be answered by the presenter at the end of the presentation. Due to time constraints, there may not be time to answer all questions. At the end of the webinar, I will provide everyone with the course number, which you will use to self-report your credits in the member portal. We are not taking attendance. I will now turn it over to the FRP Enrichment Committee CLE Subcommittee member, Logan Bartholomew.
Thank you, Diana. Good Friday, everyone. The Florida Registered Paralegal Enrichment Committee invites all our participants today to visit the FRP Corner on the Florida Bar website, as well as our various social media platforms. It is there you will find helpful tips and announcements of upcoming events and our monthly webinars. Folks, we got a good one for you today. Brean Salvo is a dedicated litigation paralegal at KL Injury Attorneys, supporting plaintiff personal injury cases from intake investigation through trial. She also serves as Palm Beach County Chapter Secretary and State NALA Liaison for the Paralegal Association of Florida, Incorporated. Thank you, Brean, for presenting today. I will now turn it over to you.
Hi there. Thank you so much. I really do appreciate the Enrichment Committee giving me this opportunity to share with everyone my worries, concerns, and our firm's thoughts on how to handle, manage, and move our cases forward in light of the amended rules of civil procedure that were enacted this January. As my introduction noted, I've been a personal injury plaintiff paralegal for many, many years. And so a lot of my perspective is going to come from that and being aggressive with case management and moving things forward. But I'm always open to conversation and hearing what everyone's perspectives is. So please, at the end of this, ask questions, email me. I'm happy to talk to anyone. So without further ado, I'm just going to jump into it. One of the things we're not going to do is talk about motions for summary judgment. It's just not a whole lot of things it's not a lot that I do in my day-to-day work for my firm. And when we do, we are early and on it. And so the deadlines are just not so important because we're dealing with it early on. So I wouldn't be very helpful to anyone on that. But rest assured, even without the changes in summary judgment, there are a lot of things that we need to talk about, including how trial deadlines and management are so strict and very, very strict at this point that trial continuances are almost a dead thing of the past. There are case management conferences that are meant to bring judges, bring the parties to a case to go over to look at an entire case at one shot. And the discovery obligations of the parties have changed dramatically. But despite the dramatic changes, there are plenty of people that have been doing this type of work for a long time. Our family law paralegals laughed at us when we were so worried about the changes because they've been doing mandatory disclosure for years, which is what initial discovery disclosure is for these new rules. They've also been supplementing their discovery responses in the federal rules for many years. So there are people, and these are the resources that we should turn to as we have questions because they've been working on it for years. I'm going to start with talking about our initial discovery disclosure, and I'm going to start with talking about what needs to go into it. It starts with your witness. It's the meat and the bones of your case. This is the paralegal's best opportunity if you have a transition of care from a pre-suit group to a litigation group. This is your litigations paralegal's opportunity to get to know your file. You're going to review your entire file and identify every witness, all the evidence, the damages, and insurance for your case, and you identify that early on in initial discovery disclosure. There are very particular things and ways that you're supposed to do it. When you identify your witnesses, you're including all of the contact information, including the email addresses and phone numbers. I'm going to share with you guys what our initial discovery disclosure looks like. Let's see. And of course, I'm happy to share with anyone these things. I'm going to hopefully share this page with you guys now. Let's see. Hopefully this switched over and you guys can see my screen. We put our initial discovery disclosures on a caption, but we serve them, we do not file them because they have private and confidential information, and the rule says that we have to serve them. We identify it as our initial discovery disclosure, and we put in our, and we put in all of our witnesses under A, our evidence under B, our damages under C, and our insurances under D. And funnily enough, the statute is written, or the rules are written so that the initial discovery disclosure follows the ABCs. Your witnesses are under Section A, your evidence is under Section B, your damages are under Section C, and your insurances are under Section D. I think a paralegal probably helps someone write the rule because that just seems too organized for the usual folks. A couple of things I'd like everyone to know about initial discovery disclosure. If I can get my screen PowerPoint to work, is that initial discovery disclosure is due within 60 days of service of a summons. That is going to be service of the summons on the last defendant, so that all summonses have been served. My firm always, as much as possible, we serve our initial, because we're a plaintiff side, we serve our initial disclosure along with the complaints within encrypted files. The other thing you need to know is that a party cannot seek discovery until it's served its initial discovery disclosure. For those people who get that immediate notice of taking deposition or interrogatories, you can put a halt to that process if you haven't received that party's initial discovery disclosure. The other couple of things I'd like you to know about the initial discovery disclosure is that you do have to identify your witnesses. You do have to identify and provide the location or copies of the evidence. So if you're in a personal injury plaintiff for an auto accident, you would have to provide copies of medical records or let them know where their location is. You would have to provide pictures of the accident scene or let them know where the location is. And then for damages, you always have to provide documentary evidence for the damages. That would be your medical records, bills, and anything that documents the pain and suffering, photographs of injuries, property damage, and the like. Those things you must serve along with the disclosure. It's not something that you can say there are copies sitting at my office that you can come and get. It's something you must serve with the disclosure. The other documents you must serve with disclosure are any insurance policies that could satisfy a judgment. This does not mean a plaintiff's health insurance policy. Plaintiff's health insurance policy can go pay medical bills, but it could not satisfy or pay towards a judgment as a result of your automobile accident. So that's just a couple of things about the initial disclosure that you'll need to know as you're preparing it. Although you don't file your initial discovery disclosure, it is not a terrible practice to let the court know and all the other parties know that you did serve your notice. And our firm does that by filing a notice of service of plaintiff's initial discovery disclosure that has a caption, a signature, and all of the good things, and get filed with the clerk of courts. And that for us is what starts ticking the other side's 60 days for their initial disclosure. Along with the new discovery requirements of initial disclosure, we now have the duty to supplement. The duty to supplement applies to initial discovery, request for reductions, request for remissions, interrogatories, and objections. The rule requires us to supplement timely. Unfortunately, it doesn't tell us what timely is. A good rule of practice is to make sure that you're reviewing your files on a regular basis to make sure that you're getting pertinent evidence and information into the other party's hand on a regular basis. We have created a practice in our firm that we have a dump file for each of our cases that are in active litigation, so that any new information or new evidence that needs to be reviewed to see if it needs to be turned over as new production, disclosure, answers to interrogatories. As we go through our case reviews, we check the dump file and we turn everything over as a supplement to the defense that's necessary. That's how our firm handles it. It's been working out so far. I would love to know what other people are doing to make sure that they supplement timely and what they interpret timely is. We make sure that we're reviewing cases before depositions, mediations, trials, and pertinent hearings to make sure that the courts, the parties, and everyone has the information that they need so that we can't get told that we were not timely in our supplemental disclosure. I know this seems a little silly, but the rule also talks about the requirement of signatures on the discovery. On a discovery request, it means when you sign it to I'll slow down. Every discovery disclosure request or response requires a signature. This is not a novel concept, but it's important that we know what that signature actually means. On a discovery request, it means that the disclosure is consistent with the rules. And the rules have changed, so we can use that in our favor and it can be used against us. So it's very important, and I'll go over those things, how the rules have changed so that we can keep an eye on that for our attorneys so that we're preparing for them and highlighting what they need to look at in a case. On a discovery response, it means that the response is complete and correct at the time that it's made. Every discovery document requires a signature by either the attorney if the party is represented or by the party itself. The interesting thing is, and for the most part that always happens, but when you look at answers to interrogatories, those are not signed by the attorney, so you might want to keep out an eye in the future that may become a requirement that answers to interrogatories must be signed by a party, by an attorney. That may become a thing. Our firm has not begun to sign answers to interrogatories. We still just sign the notice of serving. So that's the discussion about signatures and what they mean. It's important to remember that when you are serving a request for discovery, that the request is consistent with the rules. And I'm going to talk to that a little bit, because in addition to our new discovery response obligations, we have discovery request obligations. And one of them is about proportionality. The rule specifically says that the discovery request must be proportionate to the needs of the case. And the factors are the cost, the importance of the issues, the access the party has to the information, and the amount in controversy. And it's very important that we remember these things, that when we're both seeking discovery and responding to and drafting them for the attorney, so that we can make sure that we are doing our best jobs for our clients, our firm's clients, to protect their privacy and not let everything become fishing expeditions and spin our wheels responding to unnecessary discovery. To that end, I'm going to go over what some of the new discovery response obligations are. Rule 1.350 has, and that's our responses to that's our response to requests for production of things and documents. It's always been in the civil discovery handbook that we must state objections with specificity and state specific grounds. It's officially official in the rules of procedure. We must state specific grounds on objections. What's new and interesting is we must also state if we are holding back materials based on the objections. It doesn't require us to identify the type or the nature of them, just that we're holding them back. And we must produce the non-objectionable materials. The requirement to state the specific grounds also applies to answers to interrogatories when you're objecting, but the requirement to answer the non-objectionable part is not in there. So you can keep those things in mind as you're drafting answers. What does it mean that you must state with specific grounds, and what trouble and what does not stating specific grounds look like. When you're talking about, let's talk about a wage loss claim. I have a client that was out of work for 3 weeks after she sprained her ankle as a trip and fall. They asked for 5 years of tax returns, and I object because of relevance. It's overbroad and not proportionate to the needs of the case. Why do they need 5 years of tax returns for a 3-week wage loss claim? This objection, the reasons are probably valid, but your objection is not, and it's going to get your attorney in trouble if it goes to a hearing. This is better. This is where we get into the specificity of our objection. Why is it objectionable? We talk about it's a 3-week wage loss claim. You don't need that. That's not proportionate to the needs of the case. It's 3 weeks. That's the amount in controversy is just too small to make her go through that hassle. And even though you go into the specificity of why the objection is valid and why the request is overbroad, you're not done with your answer to interrogatory, your response to the request for production, because you have to state whether materials are being withheld pursuant to these objections. Well, yeah, she's got 5 years of tax returns. I'm not having her go to the storage to get them to turn them over. But you also have to turn over the non-objectionable materials. And to that end, we state that those documents responsive to supporting the plaintiff's wage loss claim are produced herewith. It'll be 3 months before and 3 months after the accident to demonstrate something like that. Another example of objections with specificity I'd like to share with everyone, every plaintiff's personal injury paralegal's favorite interrogatory. Have you ever had an incident, an accident, or an injury? And if you did, let me know your doctor, who blew your nose, and every detail in the whole world. That is grossly overbroad in 99% of personal injury cases, because if I am suing someone for fracturing my pinky, you don't need to know that in 1999, I fractured my other elbow at a concert. It's just not reasonable. And it's overbroad, irrelevant. And oops, I was going to share our lengthy objection to that, which is not pulling up. Here we go. I want to share with everyone how our office responds. Oh, sorry, guys. My link isn't working, but I think I can pull it up over here. Here we go. And when you're objecting to something with specificity, you can really get into the specifics of why something's overbroad and unreasonable. And I'm happy to share all of these materials, and if anyone wants to take a look at them. So these are just a few examples of how to answer and how not to draft answers to discovery under these new rules. Oops. If you are not responding properly to discovery, there's a whole section that let's count the ways of how we can catch sanctions on a case. Literally, it goes line item by line item, and that's just that's section 1.380, and that's for failures to conduct discovery. And of course, 1.202 gets an honorable mention because if you fail to confer, you can also be sanctioned. I'm not going to go into the nitty-gritty of what and how you can be sanctioned. I think everyone who's been a paralegal for a minute or two knows that not responding to discovery on time, being evasive, those things are not acceptable. And I think we're good about that. We just need to give ourselves the time to overcome that. However, I do want to talk about, here, and yes, I want to share, you get a sanction and you get a sanction. When I saw that rule and the various ways they lined up how you can be sanctioned, I immediately thought of Oprah and that meme from back in the day. So hope anyone got a giggle out of that. When there is a motion to compel for a failure to discovery, the loser pays. That is somewhat new in our system. I haven't seen it acted out yet at hearings, at least with our firm. But it's very important that when you're responding to discovery, when you're conferring, and I say this, we're operating underneath our attorneys' instructions, and we're assisting our attorneys in getting important issues in front of them. So I'm not negotiating the objections and that. I'm conveying our firm's positions on things and quickly getting information back and forth. So it's important as paralegals that we assist our attorneys in avoiding going to these hearings. And we can do that by always making sure that we are in contact with our clients on a regular basis, getting updated information. Doctors, have you been to the doctor recently? Have you had to spend any more money? You got a new job, your wage loss claim has ended? Be in contact with your clients. Make sure you're keeping a running list of new information and evidence. You want to make sure that you're turning that information over regularly. And you want to make sure that when you're drafting discovery responses, that you're giving full, clear, and complete responses to discovery, including those specific objections. When there is a dispute, you want to make sure that you're giving reasonable concessions and not just standing on something because you don't like the idea of it. And this is not really for paralegals because we're not the ones making the ultimate decisions, but you want to make sure that you're giving your attorneys enough information or making sure that they have enough information so that they are making correct decisions in conferring and giving reasonable concessions. Because you really don't want your attorney going to a hearing on a motion to compel because we didn't get information to them that would have resolved an issue, like a missed deposition or a CME or something similar like that. If you do go to a hearing, the loser pays. And that means that if I brought a motion to compel and the judge orders you to do what I wanted you to do, you're paying attorney's fees. If I lose on the motion to compel, then my firm is paying the attorney's fees or my client is paying the attorney's fees. And if it's a draw, the court can go either way, depending on the reasonableness of the positions of the parties. So it's really important that you're staying on top of your discovery obligations. 1.380 is strictly a section about sanctions for discovery failures. I think it's safe to say that the courts are pretty serious that we're engaging reasonably and moving discovery forward. When things are going wrong, we must confer on issues before we bring motions. Most motions require a conferral and require at filing that they have a certificate that the parties have conferred. It takes, and I've sat in a lot of CLEs. I've listened to judges at hearings because I do sit in with the hearings with my boss whenever we have, bigger issues or important case or bigger. Anyways, I sit in on hearings and I hear judges really getting into what did you do to confer? So it is not enough for you or your email to fire emails back and forth telling them your position. It is very important that you are assisting your attorney and getting them on the phone to speak with the attorney. Picking up the phone yourself and leaving a message and saying, hey, I've got my attorney, John Smith, on the phone to speak with you when they don't answer the phone is fine to assist in moving forward with that conferral. But the emails back and forth aren't going to be enough. The judges have absolutely said it. So it's important that you have that the issues have been thoroughly flushed out and that your conferral says what your attempts have been. If you can't get a hold of the other side, you can say that you didn't speak to the other side. Failure to confer and evading conference can also result in sanctions. So do not delay in responding to the parties when they have questions about your discovery responses or threatening a motion to compel. Make sure you're doing what you can to get those issues resolved as much as you can as a paralegal, and always bring the issues to the attorney as needed. This is what your certificate of good faith conference can look like. The parties conferred in good faith and reached a complete agreement. There's going to be an agreed order. The parties conferred and we narrowed the agreements, and you're going to spell out the narrowing. The parties conferred and no agreements were reached. And then you can also tattletale that I tried and I couldn't reach opposing counsel. I wouldn't want to be the one to have to say that. If a motion is exempt from conferring, you have to state in the motion that no conferral was necessary. these I think our firm has seen that these conferrals really do help resolve issues and talk about cases early on in a matter. I just lost my train of thought. I apologize. But when you do confer and you're getting in front of these issues early on, it gives better opportunity to resolve the case early on. And I think a lot of these rules are written so that the parties are constantly looking at their cases and working towards resolution or trial. As far as conferring, I think that's about it. And if anyone has anything else, I'd love to hear some questions about it. The examples of things that are exempt from conferring are going to be your motions for summary judgments, motions for dismissing, motions for extension of time on service. But don't forget, just make sure that when you do have a motion that is exempt, you're stating that it is exempt from the conferring. We now get to set case management conferences. They can be set at any time by the party or the court. If a party notices a case management conference, you're going to notice the issues that need to be heard and any pending motion. What I like about the way that this is phrased, it doesn't sound like you have to write a big lengthy motion if you're having problems getting a deposition date. It sounds like you can notice scheduling of expert witness depositions. And there are these pending motions. It gives the court an opportunity to look at a case on a whole and see what the pending issues are. When you have these case management conferences and any hearing, because any hearing can be converted to a case management conference by agreement of the parties, you want to make sure that you're giving your attorney a cheat sheet of what's going on in the case. You want to give him the docket of when your expert witness lists are coming up, when the case was served or when the case was filed and when the defendants were served and where you're at in the course of discovery and what still needs to be done in the case, because judges are asking these questions and it's really helpful if you can give your attorney a cheat sheet of this information so they're not trying to dig through their file while they're in the middle of a hearing, trying to figure out what things can be brought up and heard, because it really is a little tricky trying to figure out on the fly what needs to be addressed in your case. Courts can address that at case management conferences, any case management plan deadline issues, and there's a whole section of a rule that specifically says that these case management deadlines can be used to notify a court of inabilities to meet case management deadlines, including the inability of hearing time. Now, I find it tricky and I gotta say, if I'm having a hard time finding hearing time, I'm probably going to have a hard time finding case management time, but I'm optimistic. I have seen things I've seen things moving forward faster now and better with these rules because the judges are really digging through cases and making parties talk about issues. Last thing I want to talk about today, and I have lots of other things and pieces that we're going to talk about, is how trial continuances are truly a thing of the past. There is rule after rule that talks about we're not doing this anymore. And if you've sat in any of the UMC hearings with the judges these days, you'll hear them repeating this like it's a mantra. It goes so far to say verbatim that lack of due diligence in preparing for trial is not grounds for continuance of the case. Oh, did you forget to get an expert witness deposition? Not my problem. It's uncomfortable if you have to ask for a trial continuance. But if you do have to ask for a motion to continue trial and you have to draft one for your attorney, there are elements that must be included. And I put them in the levels of easy, medium, and hard. The easiest one is it's got to be in writing. It's got to be signed by the party. And it's got to state whether the motion is opposed. Well, as long as you can get your opposing counsel on the phone, you've got it and you can get all of that done. The medium bit is that it's got to include a proposed trial date. Do you know what it's going to take? And where is that going to be and when can it be? And you must make it immediately upon learning when you need the continuance. Those are medium hard because if it's an emergency, you might not even be able to get to the immediate motion. The hard part is really going to be describing the actions and what is going to need to happen to enable the case to move forward at the new projected trial date. And then you cross your fingers and say whatever prayers you can that your motion gets granted and you don't get sanctioned. When a court rules on a motion for trial continuance, they must state the factual basis for the rulings. Is it because you had to go to a funeral unexpectedly? It's going to be in their order. And it's going to have to set the date as soon as possible. So you're not going to get a 6-month trial continuance unless you have 6 months worth of articulable discovery requests that need to be done. So when you are moving and when you are seeing that trial continuances need to be done, you want to make sure that you're speaking with your expert witnesses, finding out what their availability is for deposition. You want to make sure if they're traveling that they'll be able to carve that in. There's a lot that goes into fulfilling the needs of the motion and making sure you're giving the court every bit of information you need that they need to get a continuance. So the courts must state the ruling, the reason for the ruling, and must set the date as soon as possible. They also may issue sanctions against the party. You don't want your case facing sanctions or your attorney facing sanctions because as a paralegal, we didn't do what we needed to properly prepare them for these things. So what does this all mean for paralegals? We got to conduct regular case reviews and conduct regular contact to make sure that we're getting updated information and documents on a regular basis, and then reviewing our files to turn it over in supplemental discovery. You want to stay ahead of conferrals by preparing and sending out correspondence stating your firm's positions. You want to make sure that you're reviewing and tracking deadlines constantly and know your judges. Sit in on the hearings and know how they conduct things so you can learn how to prepare your attorneys for these hearings and discovery issues and all the things we do as a paralegal. I think I am kind of I want to make sure that we have an understanding of how we can help our attorneys in doing all of this. When we are preparing a case for hearing these days, we want to make sure that we've reviewed the file and that we've let the attorney know if we have any deficiencies in discovery or if the defense has any deficiencies in discovery. I think I'm just about wrapped up on what I wanted us to speak about today. If we have any questions, I'm happy to start talking about that. I did not rush through, but this went a little faster than I expected, and I'm happy to chat on these topics.
We have lots of questions in the question and answer box.
Oh, that's right. That's me. I'm sorry.
No, that's fine.
We have that chat box. Give me 2 seconds and I'll start looking at it. Sorry, folks. I'm new at this Zoom thing. We haven't been doing it for 5 years yet. Nearly 6. Let's see. Of course, I did lose the chat box.
That's okay. I can read it for you if you'd
Sorry
like.
about that.
No worries. So the first question that came through is, do you serve the actual documents when you serve the responses or not? There have been questions raised that you are only required to disclose what is available, but not actually serve the documents.
So I love that question. And so let's talk about the ABCs. And if I'm good at this, we'll get this up. I'm going to try and pull that up again because I'm going to talk to you with specifics about what you do need to turn over and what just needs to be disclosed. Am I sharing my screen with a highlighted page?
Yes.
Excellent.
Yes.
Okay. So I'm going to talk about where it's talking about documents, and that's in 3 different places. The first spot of the 4 things you need to put in your initial discovery disclosure is under A, and that's witnesses. That's where I'm highlighting right here. The second thing is the evidence, which is the description of the stuff that's evidenced. And it says very specifically that you have to provide a copy or a description by category and location. Our firm does both. We say this is how we do it. the patient's medical records, the defendant's medical, or excuse me, the plaintiff's medical records are located at, HCA Hospital, are located at John Smith DO. And those are things that you just need to disclose the location if you don't disclose the actual document. However, when you get to Part C, it talks about the computation of damages, and that's your medical bills or your property damage or your wage loss, or whatever in your particular case your damages are. And for damages, you must provide a copy of the documents or other evidentiary materials. This doesn't provide for a reference of where they are. This says you got to provide the copy. The other part of your initial discovery disclosure that requires the document to be turned over is in the insurance policies. That a copy of any insurance policy that can satisfy a part or all of the judgment must be provided. So again, I think I mentioned this while I was talking. This is not about this is going to be your liability and your uninsured motorist or your commercial liability policies. This is not going to be health insurance policies, because those health insurance policies aren't going to go pay this judgment against the company that wrongly fired me. So that's what needs to be turned over versus what needs to be disclosed. I hope that helps. And I'm trying to find that question box. You were right. It disappeared immediately.
Okay, the next question is, are the IDs due 60 days from the date the last defendant is served, or the first?
The way our firm calculates it is our initial discovery disclosure is almost never needed to be docketed because we are serving it with the onset of a complaint. However, we will always serve our initial discovery disclosure 60 days to the party that we served 60 days ago. So our firm treats it individually to each party, but as far as receiving responses, we will docket the responses 60 days for the last date of service on the last defendant. I hope I articulated that clearly.
The other question is, someone made a comment. I think the attorney is required to sign the interrogatory responses if there are objections stated in the responses.
I don't disagree with you. I think that by the reading of the rule in the sign in part 1.280K, I think you are correct that because it requires an attorney, if the party is represented, to sign all discovery requests and responses. A notice of serving is not an actual part of the request. So I do think that in a technical sense, it is probably, an attorney probably needs to be signing answers to interrogatories. Our firm has not been engaging in that. And as of yet, we haven't faced anything at a hearing on that.
Okay, next question is, how are trial date conflicts being addressed, such as 4 trials being scheduled for the same time?
So I've seen that at hearings, and I've seen that on our own hearings. The judges will put you on the docket. If you don't have a special set, you're going on the docket and you're risking that call. If you are in active trial, I've never seen anyone say, too bad, you have to stop one trial to go into another. But you are juggling and you are preparing multiple cases at a time. And it's scary, and it's you lose sleep over it. The things that we can do is look at the court's trial dockets and see, are you a newer case or an older case? Make sure that you've gotten your expert witness depositions in the can if you have to. Make sure you're ahead of those schedules. You're managing the schedule of the case from the very beginning to make sure you have your ducks in a row. So it is the same shuffle that it used to be, just not with the good grace of, yeah, we'll just roll you over to the next docket because of how many you're on this time. I haven't seen that happen. I do sit in a lot of hearings with my boss because I draft the orders and we have a lot of complex things. And because it's good to know how judges are ruling.
Next question is, are privilege logs still necessary when withholding production?
For privileged documents, yes.
All right. My understanding from this CLE, the attorney physically, okay, no, this is not, I'm sorry, that was not in relation. That was a more housekeeping question. Do you have the process server print the medical records, et cetera, when serving the disclosure?
No, what we do on our firm is we provide a thumb drive or a link to documents with an encryption, sorry. And everyone handles how their firm manages initial disclosure for their particular cases. In our office, we're dealing with sensitive information, sensitive, financial information and health information. So we're sending things out encrypted. There may be other cases where it's not so sensitive and you can just send over a stack of documents.
Okay, next question. The person says, I've known to file a notice of service answers to interrogatories, but do we also have to file a notice of service on the response to request for production?
So what I think is fairly standard in Florida, and I'm not sure if maybe you're a federal paralegal or federal, if you do a lot of federal law, but in Florida, what we file is the response to request for production. So it's not a notice of serving response and then a separate document that's a response. It's a response to request for production that states the request, restates the request, states our response, and that we sign that. The documents are served separately from that filing.
Okay, on a motion to compel hearing, when the loser pays, is it, delineated whether the represented party or counsel will assume responsibility for tender of payment?
So the rules it's written, it says that, and I'm going to pull that up. Also, in the materials that everyone's getting, they're going to get an excerpt of the Florida rules with the ones that we've talked about and the ones that I feel like really hit paralegals a lot. So I'm hopeful that helps, that gives us a direction. So the rule says that my recollection is correct, and I'm pulling it up as we speak, that it can be assessed against the party or the attorney advising the conduct of the party, advising the party of that caused the conduct that caused the sanction. So it can go to either, but I am going to confirm that because that's just like vague recollection. Let's see. There was something else I wanted to mention to you fine folks about how we can manage these things. So I'm without digging in too crazily, it can go against either. If it's just a party acting on their own accord that's causing the conduct, it's probably not going to hit the attorney. And let me see, I'm pulling it up right now. Yes, and so the party or deponent conducting whose conduct necessitated the motion, or the party or counsel advising that conduct to pay the moving party's reasonable expenses and fees. So it can go against the offending attorney if they're the one who caused the conduct.
Okay, and then the last question here for our time today. How long do you need to wait after service of the initial disclosures to send discovery? That is, can you serve all discovery and ID with complaint?
So that's what our firm has done, and we have not had any issue with that. There's no, that I can see, there's no limitation on how early you can serve initial disclosure. And upon serving initial disclosure, you're allowed to seek discovery. So our firm serves the way our suit packages are, just for technicality purposes. We serve a summons, the complaint, the case management order, our initial discovery disclosure, then the discovery requests, so that they get the initial disclosure technically before they get the discovery request. And we've consistently had reasonable responses to it since the get-go.
Okay, thank you so much, Breanne. We've had a lot of positive comments come through our question and answer box. So thank you again. And everyone will receive a copy of these slides and the materials that Breanne used in her presentations. Those will be emailed to you by Zoom They will come through tomorrow. It comes the day after the seminar. You'll be receiving that through your email. So thank you again, Brean. Thank you all for attending today's webinar. The course number for today's webinar is 9475. Again, let's see here. I apologize. I want to make sure I am telling you the correct one because I've got two for some reason.
So I have just another second. I just wanted to say one more thing.
Sure.
I just wanted to let everyone know in the materials that you're getting, my email address, my contact information is in there. I really believe in collaborating with paralegals, sharing our knowledge. If you have any questions, if you have any thoughts, if you want to tell me I'm wrong and educate me, I am here for it. So please feel free to reach out to me.
Okay, and just thank you. The course number is 9485. That's a correction. Again, the course number is 9485. You will log into your member portal and input that course number, and the credits will populate there. The webinar has been approved by the Florida Bar Continuing Legal Education Department for 1 hour of general CLE credit. Again, the course number is 9485. You will receive an email tomorrow via Zoom outlining this information, and like I said, along with a copy of the presentation and other materials. I also encourage Florida Bar members and Florida registered paralegals to take advantage of the Florida Lawyers Helpline, which is a completely confidential and free service which entitles you to 5 counseling sessions per year to help you develop strategies to overcome life's challenges, balance priorities, and better handle both personal and professional pressures. This concludes today's webinar. Thank you.